point, we will move on to Divya. And what I thought we may want to, before we start, talking about the practicalities and how these guys as practitioners deal with some of the issues, I thought I may put a few questions to Divya to just look at, what is it that we had before within the context of ESCA, the regulations, and then, how this changes. So Divya, can you just give us a little bit of background what the situation was onshore vis-a-vis ESCA prior to the protocol coming into place?
Yes. So firstly, I agree with Chris that this is a fantastic initiative. I think it's just a start. And I see, we're involved, so I see a lot of, this just taking off. But I think it also sort of reconfirms the point that, which is that the UAE is not just one jurisdiction, and the fact that there are 3 jurisdictions within the UAE, and the fact that when you had fund managers or funds in the DIFC, if they did want to go onshore, they did need to comply with ESCA requirements, which is the onshore regulator. So in onshore, basically onshore in the UAE, I think there are 2 cornerstone regulations. One is the funds regulation, which was sort of reissued in 2016, and which sort of explicitly provides that funds which are established outside the UAE, if they want to access the UAE market, they need to either be registered and approved by the Securities and Commodities Authority, ESCA, and they can only be offered and marketed and promoted through a licensed promoter, which would be somebody who is licensed to conduct promotion activities by ESCA. Now, the application form is fairly comprehensive. Okay? There's a lot of detailed information required, included in relation to the offering, past performance, assets under management. Additionally, there are a lot of documents to be submitted, not just in relation to the fund, but also in relation to the various persons associated with the marketing, which is the licensed promoter and also the fund manager. And one important document is an undertaking to be filed by the fund manager that they will sort of comply with the promotion regulations. Now, in addition to the fund regulations, you've also got what was issued in 2017, the promotion regulations, which pretty much reconfirms what was set out in the fund regulations, but it covers, broadly all financial products and services which are to be promoted or introduced within onshore UAE. There are exemptions in the promotion regulations, but those exemptions are fairly limited, and they border towards promoting to maybe federal government or local government or government entities, asset managers, or those commercial organizations who are permitted to sort of, pursuant to the constitutional documents, conduct investment type activities. So there's a very important section which is your high net worth individuals who are explicitly excluded from the exemption. The other exemption is reverse solicitation, but that again is sort of narrowly defined, and it's more like an execution type scenario. And there are a whole host of continuing obligations that are placed, not just on the promoter, but also the fund manager. So the fund passporting rules are very necessary, because prior to the issuance of these rules, if domestic funds in the DIFC wish to fundraise in onshore UAE, they could only do so if either they relied on these limited exemptions or they went through a licensed promoter and registered that fund with ESCA, which could take a fair amount of time.
So this new process, where do you see the benefits then in terms of, instead of going to ESCA now coming to DIFC? Can you just maybe give us your view on some of the benefits?
Yeah, I think as Chris again rightly pointed out, it's the simplicity and the convenience of having to deal with your sole regulator, your host regulator, your regulator with whom you've sort of liaised in terms of setting up the fund. There's more certainty now vis-a-vis the, as far as fund managers are concerned, in terms of who you can market to and the activities that you can conduct in the context of this marketing without having to, consider and comply with additional requirements that are placed by another, a regulator in another jurisdiction. An example being, again, considering what exemptions apply in onshore UAE. It's all pretty clear. There's a lot of clarity provided now. I think an important benefit is, I think, cost saving. There's no real need to go through a distributor in the UAE. Fund managers and essentially persons who know the fund, who know their product inside out, can pretty much go onshore and sort of promote this. So in a sense, they don't really need to go through a distributor, and also because the distributors onshore, the promotion regulations are still fairly new, so they're just a small number of promoters that are actually currently licensed. I think an important point that you mentioned was the scope of promotion. I think that's a very, very important point because under the promotion regulations, the scope of promotion is limited. Actually, it's fairly limited. It's limited to just promoting, and licensed distributors are not permitted to conduct any kind of advisory services or dealing or act as an intermediary, whereas the definition and the scope of promotion, the way I understand it under the fund passporting rules, is fairly wide. A promoter here, subject to them obviously being suitably licensed by the DFSA, can go out there, can conduct advisory, can act as an intermediary, can deal. So it's actually, you can actually do much more than what is really permitted under the promotion regulations. These are some of the advantages.
That interestingly was one of the interesting discussions to have had with ESCA to get to that point. Just now that the regime is in place, and obviously there's been previous exemptions, can you just maybe give us a little bit of a breakdown for somebody now in the DIFC with the DFSA regulated fund? Who can they reach, say in mainland UAE? It's sort of a detailed and not, but just some sort of a view of who they can now reach with a fair amount of certainty.
Yeah. So obviously the process is, as I said, is now simpler. It appears to be less onerous, but not just that. It's in terms of you're able to now reach a wider investor base. And the first one that comes to my mind is really high net worth individuals, which were not exempted under the previous fund regulations, which are not exempted under the promotion regulations. So if you did want to target that audience, you had no choice but to register your fund and use a distributor, or else you could face sanction from the relevant host regulator. The second category is retail investors for public funds. And obviously that's subject to complying with having the relevant retail endorsement and complying with the custodian requirements. But that's again a very wide investor base in terms of public funds, which is a category of investors that I believe you couldn't truly access without the passporting rules.
Okay, final question from my side. We have this issue, and it comes back once again to the point of different legal jurisdictions, conflict of law issues, concluding contracts with particular choice of law. Do you have maybe just a few pointers to the audience now that we have this regime and we go out and you can conclude investment contracts and the like? What people should be mindful of in that context from an onshore legal perspective?
Yeah, Your question is a complicated one. There is no simple answer, and it's essentially a question about jurisdiction, and each court is free to ascertain or to decide the governing law that they will apply to govern the relationship between parties. And different courts in the UAE have their own way to decide which law they wish to apply. So this does give rise to a potential conflict of jurisdiction between the different courts in the UAE, and therefore fund managers who wish to go onshore in the UAE and who wish to advise, promote, and potentially conclude contracts in the UAE should be aware that a cause of action has arisen in the UAE. Now, the UAE Civil Procedures Court explicitly provides that UAE courts would have jurisdiction over contracts that have been concluded in the UAE because a cause of action has arisen there. There is another argument, whereby the DIFC Judicial Authority Law provides that DIFC courts would have exclusive jurisdiction over contracts, over firms that are established, involving firms that have been established in the DIFC, and contracts that have been sort of performed in the DIFC. So the position in Dubai is somewhat clear, and there are Court of Cassation judgments. There is precedent of the the Judicial Tribunal Committee, tribunal which has been established to adjudicate on matters involving jurisdiction, where they have upheld the jurisdiction of the DIFC court. So that's something very positive. But on the other hand, you've got to be careful in relation to other emirates, including Abu Dhabi, simply because the DIFC Judicial Authority Law and the Dubai Law number 16 of 2011, they are essentially considered as Dubai laws, and therefore in some of these other emirates, the courts may consider whether they want to take the DIFC Judicial Authority Law into consideration, or whether they are of the view that the provisions of the UAE Civil Procedure Code far outweigh it. So as a general, our opinion generally is that you've got to be very, very careful, especially if you are considering in opting out of DIFC jurisdiction. You've got to be careful about your contracts, clear about your governing law and jurisdiction clauses. And you have to be maybe mindful if you're going to some of the other emirates to see whether you are actually concluding your documentation in the DIFC or probably in Dubai.
Yeah, I mean, I think it comes back to the point that, at least in my mind, if you do conclude these contracts, to try and do so within the borders of the DIFC, and obviously under rules that offer an acceptance, you can word your subscription documents and the like.
Yes.
You say that this is just an offer to subscribe, and hence when acceptance takes place, it takes place within the context of the DIFC, and then hopefully the contract is seen to have been formed in the cause of action that has arisen in this particular jurisdiction. But I think it's something you've been given a lot more freedom now in terms of the protocol, but I think it's something that people should consider now that you're dealing on a cross-border basis, and the protocol does not deal with that particular issue. It very clearly states that the normal sort of rules apply in terms of jurisdiction and conflict of laws. Those were the questions that I've prepared for Divya. If there's anybody in the audience that may want to get a little bit of free legal advice whilst we're at it, then feel free to ask away.
Could you please clarify that once the fund is registered by DFSA, so will there be any additional requirement applicable for other regulators, or will this mean automatic acceptance by ESCA and other regulator? And also the point that the past funds which were registered with ESCA, So do they need to apply now to DFSA, or how is the process different for them?
Okay, so the fund passporting rules are pretty clear in the sense that it's not mandatory, it's an option. Any fund that wishes to, a domestic fund can either go that route or can continue or to decide to go directly and register the fund with ESCA. So those options continue to exist. This is not replacing, as far as I understand, this is not replacing any previous, that you can't go ahead and do that. So in terms of, sorry, can you just repeat your first question?
So once you are registered with DFSA, so will that mean automatic acceptance by ESCA? Or?
So when you mean registration, there are two aspects to it. One is the registration of the fund as such, yeah, and I think the registration under the fund passporting rules is, I think, an independent registration. It's not really the registration of a fund, but it's more an exemption permission license that has been given by the regulators to go to another jurisdiction really and to take advantage to promote the fund. So I think probably Chris, you can...
Yeah, just to add to that as well. So DFSA fund manager comes to us with an already existing DIFC fund wishing to passport. They'll submit the online application form to us. We'll then engage with the host regulator or host regulators, whichever ones you want to pick. We will give them 5 days, or we'll take 5 days to do that assessment. The assessment is the home regulators. In turn, we'll then provide the host regulators 5 days just to come back and confirm whether there's any issue with the name, whether there's a similar name in the other jurisdictions, and come back and just confirm. And at that point, they'll add the fund to their register. We'll do the same, and then go out and notify the fund manager that, and their agents that they're free to market from that point. So you'll only ever deal with the DFSA. We'll do the other work, whether it's the administration, adding things to registers, taking in fees. We'll deal with all that. You'll only ever deal with us rather than any of the other regulators.